Before we continue, it may help to pause for a moment and acknowledge something.
When families encounter missing assets or confusing transactions, emotions naturally run high.
People begin searching for explanations.
And sometimes the search for answers turns into the search for someone to blame.
That instinct is understandable.
But it can also change how families approach the legal process.
Understanding probate. Appendix F. Why probate courts resolve estates, not crime investigations. In the previous video, we explored how probate courts focus primarily on accounting and distribution.
But many families approach these cases with a different goal.
They want to determine exactly what happened.
Who moved an asset?
Who logged into an account?
And whether someone committed a crime.
Those questions are powerful.
But they are not always the questions probate courts are designed to answer.
And misunderstanding that difference can lead families down very expensive paths.
Technical investigations.
Digital forensics.
ISP subpoenas.
All of which can be appropriate in the right context.
But not always inside a probate proceeding.
Which is why understanding the court's role is so important.
Because it shapes what kinds of strategies actually move a probate case forward. One helpful way to understand this is to look at how different courts handle different kinds of disputes.
Criminal courts focus on crimes.
They investigate wrongdoing and determine whether someone violated the law.
If guilt is proven, the court can impose punishment.
Civil courts handle a different category of disputes.
They focus on disputes between parties.
The goal is to determine liability.
And potentially award financial damages.
Probate courts operate differently from both.
Their primary responsibility is administering estates,
Identifying assets.
Reviewing financial accounting.
and ensuring proper distribution.
These goals may sound procedural.
But they determine how probate courts evaluate evidence.
Information that proves wrongdoing may not resolve the accounting question.
And information that resolves the accounting question may not prove wrongdoing.
Understanding that distinction is critical.
Because it explains why certain investigative paths may not move a probate case forward, even when they feel emotionally important. Once people begin thinking in investigative terms, a particular kind of strategy often appears.
The search for a smoking gun.
A single piece of evidence that proves exactly what happened.
In technology cases, that often means looking for technical traces.
Logging records.
IP addresses.
Internet provider subpoenas.
Or computer forensic analysis.
The assumption is that if we can prove who logged in, we solve the case.
But probate courts often evaluate a different question.
Where is the asset?
Does the estate still have a legal claim to it?
And can it realistically be recovered?
Those questions may sound less dramatic.
But they are the ones probate courts are designed to resolve.
This does not mean technical investigations are useless.
But their usefulness depends heavily on context.
And on whether the evidence actually answers the probate court's question.
Otherwise, families may spend months pursuing proof that does not resolve the estate.
Which is why strategic alignment between investigation and legal process becomes so important.
And that brings us to another critical factor: the difference between investigative advice and legal strategy. Another important distinction often appears in complex cases.
Is knowing how investigative advice and legal strategy differ.
Investigators are trained to uncover technical evidence.
They look for traces,
Patterns.
And connections between systems.
From their perspective, the next logical step may be deeper investigation.
Tracing IP addresses.
Subpoenaing internet service providers.
or conducting detailed forensic analysis of devices.
Those steps can be technically valid.
But legal strategy asks a different question.
Will this evidence change the outcome of the case?
Will it help the court resolve the estate?
Or will it simply create more investigation?
Sometimes the difference between those two perspectives becomes significant.
An investigator may see unanswered technical questions.
An attorney must see a legal path forward.
And courts ultimately respond to legal arguments.
Not technical curiosity.
Which means investigation must ultimately support the legal strategy.
Not replace it. And that alignment becomes especially important in probate cases. Because the court's focus remains the administration of the estate. Once investigations begin expanding, another practical factor enters the picture.
Each new investigative step can trigger another layer of legal work.
A request for internet provider records may require subpoenas.
Those records may then require interpretation by technical experts,
which can lead to forensic analysis,
detailed reports,
and sometimes expert testimony.
At that point, the case may begin resembling civil litigation,
which can dramatically expand both time and cost.
Sometimes far beyond the value of the asset being pursued.
This is one reason attorneys often approach investigations cautiously.
They must weigh potential recovery against potential expense.
And determine whether the path will actually help resolve the estate.
Because probate courts still require a final accounting.
Assets must still be identified.
Values must still be established.
And distributions must eventually occur.
Investigations that do not move those steps forward may not help the probate case.
Even if they answer interesting technical questions.
Which is why the final step in any investigation is often strategic.
Deciding whether the path actually helps resolve the estate. So when families reach this stage of a case, the discussion often becomes strategic.
Not simply what happened.
But what path forward makes sense?
In practice, most situations fall into three possible directions.
The first is continuing within the probate framework.
Resolving the accounting of the estate.
Determining what assets are known.
And distributing the estate accordingly.
The second option focuses on asset recovery.
Tracing assets that may still exist.
Determining whether the estate can legally reclaim them.
And whether recovery is economically practical.
The third path is a full investigative or litigation approach.
Attempting to determine exactly what happened.
Who may have been responsible.
And potentially pursuing separate litigation.
Each of these paths has different costs.
Different timelines.
And different probabilities of success.
Understanding those trade-offs can help families make clearer decisions.
Especially when emotions and uncertainty are involved.
Because probate cases eventually require a practical resolution. And the strategy chosen will shape how that resolution unfolds.